Agyemang V The Republic, 1995 to 1996, 1 Ghana Law Report 118. This is also a criminal law case which deals with murder and provocation. The facts are that the appellant killed the deceased with a cutlass and he was arraigned before the High Court on a charge of murder contrary to Section 46 of Act 29. At the trial, he relied on the defense of extreme provocation under Section 52A of Act 29. In support of his defense, he testified that he had suspected his wife of having had an affair with the deceased, and therefore he became very angry when at the funeral the three of them attended. He saw his wife dancing adowa with the deceased, and at a point she wiped the deceased's face with her handkerchief. Therefore, when subsequently the deceased and his wife disappeared from the funeral grounds, he became suspicious. He then went and took in some drink, picked a cutlass, and went to the deceased's house. He claimed that as he stood behind the door, he heard his wife's voice from the room, but thereafter there was silence, which made him suspect that they were having sex. Consequently, when the deceased came out of the room, he struck him with the cutlass and killed him. The trial High Court rejected his defense, found him guilty, and convicted him of murder. Aggrieved by his conviction, he appealed to the Court of Appeal. The court held, dismissing the appeal, that since Section 53(1)(c) of Act 29 requires that in order for an act of adultery of a spouse to constitute extreme provocation, the accused had to have seen his spouse and another engaged in the actual act of adultery. No test, whether subjective or objective, applied. The only matter for consideration was whether the accused saw the deceased and his wife in the act.